to a union traditionally designated as marriage. As past cases established, the substantive right of two adults who share a loving relationship to join together to establish an officially recognized family of their own, and if the couple chooses to raise children within that family, constitutes a vitally important attribute of the fundamental interest in liberty and personal autonomy that the California Constitution secures to all persons for the benefit of both the individual and society. End of quotation. Therefore, the court found that the California Constitution establishes a fundamental right founded primarily on the right of personal autonomy to marry. The state of California's response to this position was, well, okay, the Domestic Partner Act affords this right to same-sex couples. States did not have to assign the word marriage to a relationship that had all the same legal rights and duties as traditional marriage. And now again, I'll let the court speak for itself. This is how the court dealt with that. One of the core elements of the right to establish an officially recognized family that is embodied in the California Constitution, the California constitutional right to marry, is the couple's right to have their family relationship accorded dignity and respect equal to that accorded other officially recognized families, and assigning a different designation for the family while reserving the historic designation of marriage exclusively for opposite-sex couples poses at least a serious risk of denying the family relationship of same-sex couples such equal dignity and respect. Close quote. The court then moved to an analysis on equal protection grounds. It found that strict scrutiny was the appropriate standard to apply to California laws reserving the word marriage for heterosexual couple. It had determined that marriage was a fundamental right. We just heard that. It also decided that sexual orientation was a suspect classification. The court found that the state had no compelling interest in reserving the word marriage to heterosexual couples, and that denying the word to same-sex couples while bestowing it on heterosexual couples was not necessary to serve any interest the state may have in heterosexual marriage. And once again, your California State Supreme Court speaking directly to you. A number of factors lead us to this conclusion. First, the exclusion of same-sex couples from the designation of marriage clearly is not necessary, in italics, in order to afford full protection to all the rights and benefits that currently are enjoyed by married opposite-sex couples. Permitting same-sex couples access to the designation of marriage will not deprive opposite-sex couples of any rights and will not alter their legal framework of the institution of marriage, because same-sex couples who choose to marry will be subject to the same obligations and duties that currently are imposed on married opposite-sex couples. Second, retaining the traditional definition of marriage and affording the same-sex couples only a separate and differently named family relationship will, as a realistic matter, impose appreciable harm on same-sex couples and their children, because denying such couples access to the familiar and highly favored designation of marriage is likely to cast doubt on whether the official family relationship of same-sex couples enjoys a dignity equal to that of opposite-sex couples. Third, because of the widespread disparagement of gay individuals historically have faced, it is all the more probable that excluding same-sex couples from the legal institution of marriage is likely to be viewed as reflecting an official view that their committed relationships are of lesser stature than the comparable relationships of opposite-sex couples. Finally, retaining the designation of marriage exclusively for opposite-sex couples and providing only a separate and distinct designation for same-sex couples may well have the effect of perpetuating a more general premise, now emphatically rejected by this state, that gay individuals and same-sex couples are in some respects second-class citizens who may, under the law, be treated differently and less favorably from heterosexual individuals or opposite-sex couples. Under these circumstances, we cannot find the retention of the traditional definition of marriage constitutes a compelling state interest. Accordingly, we conclude that the to the extent the current California statutes provisions limits marriage to opposite sex couples, these statutes are unconstitutional. Well, so that's a brief summary of how your California State Supreme Court decided the word marriage could not be constitutionally reserved for heterosexual couples. As we are all aware, the people of this state passed Proposition 8 in response to this ruling. Proposition 8 itself was challenged in the California State Supreme Court on the grounds that it was a revision of the Constitution and not really an amendment, and therefore required prior approval of either the legislature or a constitutional commission. Prop 8 survived that challenge and is now part of the California Constitution. However, notwithstanding Proposition 8, I submit that the following are now some of the elements of the legal environment of marriage and family here in California. 1, the right to marry, and I believe they would find the right to form a family, whether through marriage or domestic partnership, is based on the individual's right to liberty and personal autonomy. 2, same-sex domestic partnerships, families in the eyes of the law, are the legal equivalent of heterosexual, Prop 8 if you will, marriages and their families. 3, all families have the right to have children, quote, through means of assisted reproduction, unquote, if they desire. Therefore, under California law, domestic partners and married couples seem to have the right to cause the procreation of a child and intentionally deprive that child of the aid, society, comfort, and knowledge of one or both of the child's biological parents. 4, given the California State Constitution's view that families, and we must always remember that under California law, this means domestic partnerships equally with marriages, have the right to be officially recognized, and protected. It would appear to me that an amendment to the California Constitution would probably be necessary to repeal or substantially reduce the scope of domestic partnership laws here in California. And that is irrespective of Prop 8. And 5, given that the California Supreme Court has found that sexual orientation is a suspect classification, no statute or legislative initiative could give any recognition or benefit to heterosexual couples that it does not give to same-sex couples other than the title of marriage, which is constitutionally permitted under Proposition 8. I think that sets out the legal environment for marriage and the family in California. Now, what first strikes me is the poverty of constitutional analysis available to the California Supreme Court. It's based on a very limited view of the human person. To begin the conversation about the right to marry from the standpoint of personal autonomy is essentially to give away the ending. California constitutional law appears to be blind to the fact that people are inherently social beings, that we are relational in nature. We, as an engendered species, are quite literally fit for the relationship of marriage. The complementarity of the sexes makes us fit for the most intimate personal union, which by its nature is fit for procreation, rearing and educating children, the continuation of our species, and the passing on of our culture. The legal significance of all of this was cast aside with a flick of the judicial hand. As a practical matter, the natural law has been outlawed in the California legal environment for the family and marriage. For those of us who hold that the family, based on the mutual self-giving of husband and wife, is the first vital cell of society, and accordingly the basis of social justice, this is highly problematic. Finally, it's not tolerable and must be opposed. Moreover, the real value of marriage must find expression in the law.